All right, we saved the most exciting topic for last, will and trust disputes. On our panel, we have Mr. James Wright, CPA with Carr, Riggs, and Ingram. Ms. Stephanie.Duffield, financial advisor with Edward Jones, and attorney Jim Green with Clark Partington.
All right, well, good morning, everybody. Thank you so much for sticking around for the last session. We promise it will be well worth your time. So we wanted this to be a conversation between you and us, so feel free if you have questions along the way to raise your hands and ask the questions, and then we'll also have a second question and answer session at the very end. But this particular presentation is called Will and Trust Disputes, and we all know what that is just by the terminology. And as a financial advisor, I always say we want to have these conversations now while we're happy and healthy, because if something happens to someone, to your parent, and you haven't had these conversations about mom and dad, what's going to happen to, when they pass, or yourself, if you get a terminal illness, we've all been through these experiences, and rushing through these conversations when you have an end date in sight and when things are very emotional when someone's sick just becomes very cumbersome and a big burden to really that person and the entire family. So today we wanted to have conversations, and we're going to start with some simple case studies about things that have gone wrong in our individual practices. And so we wanted to make this very personal, just to highlight some things that could have been done a lot better or a lot more efficiently, which would have ended in a much better result. So the goal really is, if you take one little nugget away from this panel, and even if you've done your estate plan or your trust plan and you realize, you know what, I better think through that piece of the puzzle, and you make that change now, we will feel like we have had a meaningful impact today. So this is James Wright from Carr Riggs. He's from our Blue Water Bay, or his Blue Water Bay office. And this is James Green. He's an attorney with Clark Partington in Pensacola, and I'm with Edward Jones Investments in Destin, Florida. All right. So I think the last panel did a good job. I'm glad they ended it talking about the difference between a will and trust. So we're going to just start with, again, a case study, and I'm going to talk about a real-life experience that ended up being an absolute disaster and actually happened in this last year of my practice. So I've titled it The Life Insurance Beneficiary Disaster, and I was working with this particular doctor for several years, a very high-income earner, made over $800,000 a year. He moved to this area from Tennessee, had a really their dream home in Tennessee, lost his job. He was a 1099 contractor. So he came into my office, and we put some really thoughtful, meaningful planning in place with a big defined benefit plan, which allowed him to put, a couple $100,000 away a year, tax deferred, and some 401k buckets. So that's really how I met him. At that time, his wife was a teacher living in Destin, and he ended up having a third residence in Pensacola because that's where he ended up working. So very convoluted, very expensive situation for the first few years. The market wasn't really moving in real estate, and so they were kind of floating two mortgages and rent, I should say. This got very expensive, and he fell ill with cancer and ended up having a very long battle with cancer. So I know on my end as a financial advisor, I have to be very thoughtful and go over each and every asset. And we did that within my book of business, and we did that outside of what they had done prior to what we did together as well. And, we did things at that stage like add the wife to the defined benefit plan so that she, when he got sick, could call in and give me instruction on the accounts to liquidate the assets. We're so glad we did that, because we did liquidate those assets over the course of a couple years, down to just a very small bucket that when he passed he left behind. And also it gave us the ability after he passed to just move through closing out those accounts. They're a little bit more cumbersome, they're complex in nature, so we were able to close out those accounts very efficiently. But there was one piece of the puzzle that offered a lot of solace to his wife, and it was this life insurance piece that he had been sold years before, and we were so glad he had it, because obviously he was very quickly after I knew him uninsurable. And we'd always talked about it, I'd seen the policy, and we always just knew that was what was going to take care of his wife after he passed. Well, lo and behold, he passed away. And very, very unfortunately, the beneficiary was a trust that was never finished being created and never funded. So the wife thought she would receive this very large tax-free inheritance, which is now still going through probate. So it's been a very painful situation, very emotional, and could have very easily been dealt with if he would have allowed me a little bit more transparency. But at that stage of the game, he was very sick. And remember when I said at the very beginning, you want to have these conversations with when you're happy and healthy? Sometimes things like that become very emotional towards the end. Second disaster was a real estate crisis. So lovely client, was widowed for several years, had a beautiful house on the water. Her largest asset was this house on the water, had 4 children, and had memories for decades in this house on the water of her kids and grandkids. And her wish was really to leave it to her kids. So she got her wish. She passed away. The house went to her children. There were 4 children. One of them was a very high income earner. Another one, upon her passing, had lost their job, wanted to move into the home. And the other 2 were happily married, housed spouses, and, just the day-to-day with their kids and whatnot. So not thinking through what that would look like, things became very contestable after she passed. The one child moved into the house. They couldn't support all the bills equitably, and the other 3 were not so happy to pay for the one, sister to live in the house. So essentially what happened was it ended up in a lawsuit. They ended up selling the house, and I really think with this particular client, if she would have known how things would have ended up, things could have been done differently. So, I always say with clients, I'm not allowed to give I can give financial advice, I'm not allowed to give legal advice or tax advice, but I just walk through these cases with clients because, if you have a situation like that in your family, it just ends up being very emotional and not really meaningful. I think she would just be devastated that her kids don't really talk now. So that's my 2 cases.
All right, as everyone's already said, my name's Jim Green. I'm an attorney, and part of my practice involves estate and trust litigation. And one of the things I get asked to do by clients frequently is to help them evaluate whether or not a will or a trust is itself a valid instrument. Because under certain circumstances, you can have one of those set aside. For example, what if you have gone to meet with a financial planner and you've met with a lawyer and you've got a will and you've got a trust and maybe you amend it 2 or 3 times as your circumstances change and you're hoping to take care of your children, and then you fall ill at the end of your life, you have an in-home caretaker who the children have no reason not to trust, but when you die, they find out that there's a will that undoes all the planning you had done with your planner and your attorney and gives everything to your end-of-life caretaker who you really didn't even know. Sometimes there will be one sibling who thinks they deserve it all and will isolate the parent from the other siblings and manipulate them into believing nobody cares for them except for that one child, and therefore you should leave it all to that child. That's something else that could potentially be set aside. I'm glad they talked about the blended family earlier, because the example I've got up on the slide I've called the stepchild dilemma. But this is a situation where 2 people had children from prior marriages, and they owned real property individually prior to their marriage. They get married, stay married for 40 years. They get close to their stepchildren. They create these mirror image wills that say, my individually owned property goes to my biological child, everything else goes to my spouse, and if they predecease me, then everything's split between all the kids. In this particular instance, the mother had a daughter who lived out of town, and the father's children were in town and helped take care of her when she got cancer, took her to all her appointments. The dad dies in October. The daughter comes in town, takes the mom away, starts taking care of her, won't let anybody else see her, ends up getting a will from her mom that leaves her everything, ends up getting deeds to her from the jointly owned property that was supposed to be divided among all the kids. And then the mom dies 2 months after the dad, and the children of the father are thinking, what happened? We were supposed to split it between everybody, and now she gets everything. So there are different mechanisms under the law that allow you to challenge a will or a trust, or even a life insurance beneficiary designation, even a joint account ownership designation. And after we finish the case studies, I'll speak a few minutes more about what to look for to see whether or not, under your circumstance, one of those documents can be challenged.
Good afternoon again, and thanks for hanging with us here in person and watching online. So a lot of times when the accountants are brought in, it is definitely for us to crunch the numbers. And so this was kind of one of our situations, which I call sisters versus brothers. Dad had already passed away. Mom dies. There's 4 siblings. And we've got plenty of estate documents. All that stuff's pretty and nice. It leaves everything equally among all siblings. But unfortunately, one of the siblings did not believe that the accounting had been done properly, the assets had been valued properly, and thought they were entitled to a larger share than what was being proposed. So we had to come in, and the eldest son, which typically happens, the oldest sometimes is left as the executor. And I will make this comment. That is kind of a common theme that you see, that the oldest should be the one who's left in charge, but it may not need to be the oldest. Maybe it is the middle child or the youngest child that has a better acumen for that. I'll take my family example. My grandmother recently passed away, and my mother is the oldest, but she is, bless her heart, she's wonderful, but she is not a business person. My uncle, who is the youngest, there were just 2 siblings, is the business person. So he was rightfully named the executor, because even though maybe, and my grandmother actually asked my mother before she did it, because of that old thought process that it needs to be the oldest. Do you mind? And of course she immediately said, please do. I have no problem with it whatsoever. So in this case, it was the eldest son who was perfectly capable of being the executor of the estate, but because they were responsible for doing the accounting, and I will recommend, depending on the size of the estate, it may not always matter, but sometimes it is better to get a CPA in on the front end to do the estate accounting, so that if there's any issues, the executor can at least come back and blame the accountants versus blaming the executor who's trying their best but maybe has not had to deal with this before. So we had to come in, we had to do a whole new estate accounting. There was some multiple properties and stuff, so we had to get some assets valued. And the sad part about it is we were representing the estate, so we were the CPAs hired by the estate. The sibling that was challenging everything had hired her own experts. You had to have a lawyer for the estate. You had each beneficiary had to have a lawyer, even the children that were on the side of the estate. And unfortunately, accountants and lawyers, we sell our time. And that's how we make our living. So we had to get paid for our time. And Mom passed away in 2011. This finally was settled at trial last year. So you've had that long a time of this going back and forth. Unfortunately, I fear the relationship among the siblings is irreparably harmed. The one sibling that is challenged has been outcasted by the 3 others. And in the end, they would have all gotten more money in the shares if they could have had to come to an agreement before they got all the lawyers and accountants involved. Not to mention all just the emotional tear that this took on everybody, especially it getting stretched out so long. So sometimes you can have the documents, they can be beautiful, they can be doing exactly what Mom intended, but there's no way, kind of like to Stephanie's point in her example, that Mom would have wanted her children fighting like this. So that is kind of some of the sad things that can happen from time to time. So now we're going to go back to Stephanie talking about a few of the things that are involved with wills and trusts.
Okay, so Also, you want to be really thoughtful about who you choose as either a trustee or an executor. So we just went through in that last panel. They did a good job illustrating the difference between a trust and a will. And an executor is the person who's in charge after someone passes when there's a will. And the trustee or co-trustees is the person or people who are in charge after one's passing when there's a trust that's put in place. So I just want to point out very thoughtfully that you really have to be thoughtful about your designation of if you have an institution or if you designate a person to accept that responsibility. Because sometimes people will say, you know, I want this uncle. This uncle is wonderful in our family. My kids would absolutely respect his judgment. I want him to be the trustee. Sometimes the uncle agrees, but might regret it years later. So I just wanted to highlight a quick story. Again, happened within my book of business. I have a trustee who's been managing a trust I've been working with him 11 years, and the trust was ongoing prior to that. It's like the previous presenter mentioned, trust makes sense, especially when something goes on a long time. So this was a very large estate, and there are 2 adult children, and the way Mr. D, is what I'll call him, wanted things dispersed was so much every month, but then there's the ability for the trustee to make decisions along the way about whether or not Mr. D would want the trust assets dispersed for whatever instances come along in life, right? So this particular trust was a single trust created years ago. Client passed, his best friend, my client, is the trustee of the account. One of the beneficiaries got cancer and so went to the trustee saying, hey, you know, I've got cancer. Can I have an allotment in addition to my monthly allotment from the trust? Can I take a disbursement for my cancer treatments? Well, he had to think through, what would Mr. D want? Well, yes, absolutely. The other one had some addiction issues. Well, would Mr. D want me to do that? Well, anyhow, the trust started being dispersed unequally, and it was very hard for him to keep track of, and he was so nervous about being sued. So he went before the courts and had the trust split into 2. Well, a couple years later, the trust is now 2 trusts, and these 2 beneficiaries receive their monthly, allotment in their bank account from my branch. I'm managing the assets, and one of them, their cancer came back and they passed away. Well, the way the wording of the trust was worded was that that person's fair share would go to the other sibling, the sister. Well, he thought, I don't think this is what Mr. D would have wanted. This particular person has an only child, and I think Mr. D would have wanted her assets to continue on to her child. Well, guess what? He had to go back before the courts and argue that his friend, Mr. D, would have wanted this to happen. So I just share that story because I can't tell you how many times he said, I wish I would have never agreed to be the trustee for this account. He cannot wait until it runs out. And, unfortunately, there's other assets that will, come into play that will future fund the trust. I mean, this is going to be going on quite some time. So I just want to be thoughtful about that and share that with you because it's a very heavy burden, especially if it goes on years like that. And a lot of people think, well, it's a cheaper option. Institutions charge 1 or 1.5%. I don't want to do that. Well, usually these people end up, even if it's not written in your trust, my client takes a payment. I mean, it's a lot of work, right? And he charges less than the bank because morally he feels that's, the right thing to do. But I just want to mention it's a burden. And then, titling the assets appropriately. If and when you do these things, I've met people when they come into my office and I'm like, well, great, let's talk a little bit about estate planning. Tell me about what you've done. Oh, we have a trust. And I look at their Wells Fargo statement or whatever it is before they transfer it to Edward Jones. And I'm saying, well, why aren't your assets, why isn't your $800,000 account in your trust? Oh, well, I don't know, and really, you have to think about it. These trusts are just a piece of paper until your assets are titled. So, when you have a trust, please make sure that you provide the trust information to the financial advisor and we're able to title your assets appropriately. And if you choose not to create a trust, please make sure you also have that conversation with us. And a good financial advisor will proactively have this conversation with you, but we'll put something called a transfer and death on the account. And I always encourage clients as well, do this at the bank too. So when you go to the banker is most likely not going to say, put this payable on death on your $10,000 account. Well, I've seen from experience it actually happened to my mother before I was a financial advisor. She had an account, we met with attorneys, And the attorney said, all of that's going to get eaten up with fees, so you might as well just leave the asset and come back years later and try to, if there's some left, you can come after the asset essentially. So really, really difficult things, but again, make sure things are titled appropriately. Next slide, please. Oh, perfect. That one. Then you also want to just make sure that you update things. Life changes, and one of the great things about, say, if you create a trust is that they're amendable, right? We've heard that several times this morning. So just because, I always tell clients, it's always the right time to do the right thing, even if your mind might change. And it's often the case where we'll have a new grandchild be born, or there's a divorce in the family and that type of thing. So you'll want to make sure every couple years, and sometimes attorneys are really good about this, they'll send a letter out to clients if they've created a trust and just remind clients to look at their trust documents every 2 to 3 years. And really that is something also that I'm really passionate about doing in my practice is, hey, have there been any updates since you created this trust 10 years ago? Okay, let's think through those. Does it make sense to have an amendment? Okay, let's put you in touch with an attorney who can create that for you. And then lastly, I just want to talk about the importance of transparency. All of these documents, as I mentioned, are just documents unless someone knows where they are at execution time. So we heard the phrase living will, health care directive, power of attorney. It is horrible when the financial advisor doesn't have a power of attorney on the account and someone is sick, and all of a sudden, you're having to rush things and get the power of attorney and have your legal department review it. It's just a mess. So again, please, if you have the documents, share them with us. And also on the flip side of things, it might make sense for you to download an app. I know everyone's kind of moved to having things on their cell phones these days, but think about getting that call from, your son in Montana or whatever, or, your son in Montana gets the call that you're in a coma, and he flies out here, and he knows he's the decision maker, but he has no idea where the documents are. Well, there's some great apps. There's one called Evernote where you can actually download those documents on your phone, and so you can show up at the hospital and show them, here's the living will, here's the healthcare directive, I'm the person who's in charge of making these decisions for my mother. So you just want to be thoughtful about that. If you don't want your beneficiaries to know how much they're going to inherit, that's okay. Just let them know where to find the documents, safety deposit box, in the library, third shelf, whatever. Please let them know where those documents are, and if you're comfortable enough, giving them a copy is also really, really meaningful.
All right, well, there are 3 ways you can challenge a will or a trust. And the first way is if they're not properly executed. One thing that's important to realize is under Florida law and under most states' law, there's a presumption in favor of the validity of these documents because the only person who really knows whether it contains their true intent is dead by the time you're challenging it. So one way they help ensure that the documents contain the true intent is require that they be witnessed by 2 witnesses. And there are certain rules about how it has to be signed in Florida. People can do it on their own, but if you want to make sure it's properly executed, I think it's worth hiring an attorney to supervise the execution and to draft the documents to make sure everything works the way you want it to. But if it's not properly executed, it can be set aside for improper execution. The second way you can set aside one of these documents is if the person lacked the mental capacity to execute the document at the time it was executed. Because of the presumption of the validity of these documents, the testamentary capacity test is the lowest test under the law for mental capacity. All you have to know is who the objects of your bounty are, and that means the people who have a claim to your estate after you die. So if you know about who you're married to, if you know who your kids are, if you don't have kids, who your brothers or nieces and nephews, if you can keep those people in your mind, while at the same time understanding in a general sense what your assets are. You don't have to know how much money is in your accounts, but you have to know you have accounts. You may not have to know every single piece of property you own, but you have to generally know you own property. And so you have to be able to keep in your mind who the objects of your bounty are, what you own, and then understand in your mind the consequences of leaving it to one person, but that means it's excluding these other people who have a claim. If you can do all that at once, you have testamentary capacity and the will would be valid. Another important thing is people in their old age, they fluctuate. They have good days and bad days. And under Florida law, you can have a lucid interval, which means for that day, you were good enough to execute it, even though generally you may not have been. And then the last way you can set aside one of these documents, which is where most of the time it falls under this category, is called undue influence. Sometimes they say coercion, duress. But basically it's where one person basically overpowers the free will of the decedent and gets them to do something that they didn't really want to do, but it's what the person benefiting wanted to do it. And it's usually done in secret, behind closed doors, so nobody knows it happened, like in the example of the caretaker who just shows up with a will. Or it can be a sibling who just shows up with a will. I've actually had cases where it's parents against the surviving spouse's widow or former husband. But because it's done in secret, under Florida law, they've created this presumption of undue influence where you can prove certain circumstances. And the circumstances are, there was a confidential relationship between the decedent and the person who's benefiting from the will. That's almost always true. A caretaker gains your confidence. They rely on you. They trust you. Caretaker can tell them things like, I'm the one that's helping you. Your kids aren't around. Those kinds of things. The second factor is the substantial beneficiary, which is basically always the case, because if they're not changing it to the detriment of others and the benefit to themselves, you wouldn't be challenging it. And then the third part is called active procurement. And that just means the person benefiting was involved in obtaining the will. There's several factors they consider this, like if the person who's benefiting is present when they sign the will. If the person who's benefiting is present when the testator expresses a desire to make a will. If every time they said they want to give it to me, I'm sitting there right next to them, well, maybe that's because I've coerced them into believing I'm the one that's there for them and nobody else is. If they get the attorney, in the example I mentioned earlier, the surviving spouse, the mom, had an attorney who had done the prior estate planning and who was helping her probate her deceased husband's estate. Well, the daughter takes her to a totally new attorney she had never met before and gets her to do a new will and doesn't even tell that attorney that she has stepchildren. Knowledge of the contents of the will prior to its execution, keeping it safe after the will is executed, getting your friends to execute the will. These are all things that are included in the law because they're things that happen all the time. Where earlier people were talking about maybe you have one kid who you don't think can handle having all the money. Well, sometimes there's one kid who thinks I'm entitled to all the money, and they're very, I have clients who describe these kind of circumstances, and then I can tell them all about their sibling who took everything because have so many similar characteristics. They usually think they're the smartest person. They think they're the most entitled. Sometimes you could call them a narcissistic type of person. And when I start describing it, they're like, that's exactly right. That's my brother. I can't believe you know all this. Well, I'm like, that's because I've done this 100 times and it's just a repeating circumstance. So, I guess the point of this is when you're in a family situation and you think your parents have done all the planning necessary and you've got all this history of wanting it to be done equally, and then at the end of the day, it ends up all going to one person, there might be something they can do about it, and it's definitely worth calling someone like me or another estate litigation attorney to at least find out whether or not those documents are subject to challenge or valid. And as I said earlier, you can challenge all kinds of instruments controlling what happens after you die.
Okay, so kind of when I was talking about earlier, like from our perspective, when do the accountants come in? And like I said, it's typically we're hired by it could be the personal representative or the executor of the estate, the beneficiaries, or both. Normally by time we come in this case, it's already gone to the point where there's going to be at least the beginnings of litigation. Everybody hopes that you can settle and those types of things, but there is some kind of litigation track started. Obviously, since it's litigation, the attorneys take the lead. So we work with the attorneys based on what they need us to do, what the issues are. Is it challenging the actual accounting of the bank account? Or it may be that part of the assets is a family-owned business. So do we need to come in and value the business? Maybe there's a dispute on the value of the business. And so our role basically really depends on the situations involved as well as what the attorneys need. And then a final thing to kind of keep track of, and Luke talked about this a little bit earlier, but are the estate tax issues. As we discussed earlier, the estate tax exemption is at 11.2 adjusted for inflation, so it's actually 11.58 for 2020. So a lot of people think, well, I don't have that much assets, so I don't have an estate tax. Well, with estates, there are two taxes. There is the estate tax, but there's also the income that is generated off the estate assets. And if you have income of gross income in an estate of more than $600, the IRS says you must file an income tax return for the estate. So the income from estate assets can be taxed at two different levels. They can either be taxed in the estate if distributions have not been made to beneficiaries, or if the assets are distributed to the beneficiaries, then the beneficiaries on their personal income taxes would pay the associated taxes based on their personal income rates, taking into account anything else they might currently have. From a tax savings standpoint, as Luke mentioned earlier, the tax rates on estates and trusts are very condensed. For 2020, if you have income over $12,950, you're taxed at the top rate of 37%. That also means that if you have capital assets, you're already at the top rate of 20 or 23.8% on capital gains. Whereas to get to the 37% on an individual's basis for married filing jointly, you'd have to have $622,000 of income before you got there. So from a tax perspective, if distributions can be made and there's no issues, we encourage that because it does save money in the family pot, because not as much of it is going to Uncle Sam. But in order to do that, the cash or the assets actually have to be given to that person who is going to be expected to pay the taxes. So they need the rights to that income. So that's something that some people I talk to all the time, they think, well, I don't have a estate tax problem because I don't have $11 million. But is it a brokerage account with Stephanie that's still throwing off capital gains and interest and dividends, or at a CD or a money market account at the bank that's still throwing off interest and dividends? Like I said, there may be some other expenses you can take, so you may not have taxes due, but if it generates over $600, the IRS says we want to see a tax return. So those are a couple of things to keep in mind. And so that kind of brings us to the end of our piece of this. We would definitely love to take any questions if anybody has any. We certainly appreciate everyone's time and being with us here today in person or watching online.
Can you repeat that question?
Sure. The question was, what is the average cost of a will or trust dispute?
I know it's a really hard question.
So that's a wide range. Okay. The low end is going to be $50,000 to $75,000, and the most I've been involved in is several $100,000. So it's very, very expensive. And what James mentioned earlier is sometimes all of the estate ends up in the hands of the attorneys and the accountants, and the courts don't like that. But sometimes people are just unable to get along. I'll tell you a real quick joke. My dad used to do estate litigation too, and he said that the difference between a divorce and a will contest among siblings is that instead of having half your life to learn to hate the other person, you've had your whole life to learn to hate the other person, which is a sad but sometimes true statement.
Hey, just want to thank everybody again for coming. Thank you to our online participants, and hopefully we will see you again next year. And we do want to remind everybody that we have some of the supplements available for the people in the room, and we will have a link to the supplement posted on our website and our Facebook page. So thank y'all again.
Hancock Bank and Whitney Bank first worked together in 1918. In 2011, the two banks merged to become one company built on 5 timeless values: strength and stability, honor and integrity, commitment to service, teamwork, and personal responsibility. With this foundation, our mission is to help you reach your dream. One bank, one mission, 100 years in the making. Hancock Whitney. Your dream, our mission.